You are listening to the Divorce and Your Money Show, the #1 podcast that discusses the complex business of divorce. I'm your host, Sean Lehman, MBA and certified divorce financial analyst. And on today's episode, I've been really looking forward to interviewing today's guests. Now, they're experts in an area of divorce that is super complicated. And because it's so complicated, no one really seems to talk much about it, and that's a big mistake because it also deals with one of the biggest financial assets that you will likely have in your divorce. And on top of that, it's an area that I can't teach you about, that I have to bring in the big guns, as we say. So what are we talking about? Well, today we are talking about quadros. And I'll tell you what that means in a little bit, and you'll hear it more in the actual episode. But what's the biggest asset outside of your home? Well, it's likely some kind of retirement plan. I mean a pension plan, a 401k plan, or an IRA in some cases. And if you're getting divorced, you're going to need to come up and split the funds. Well, what you don't realize about retirement plans, one of the reasons I do this show and one of the reasons I interview experts is sometimes there's areas that you will not have ever even heard of, considered. Your attorney won't bring it up until it's too late. Sometimes attorneys don't even know what's involved in this process. And so I want to bring these experts directly to you. And so if you have a retirement account, you can end up in a position, and believe it or not, I see this all the time, where you sign the papers, the judge enters the divorce decree, and you say, all right, well, how do I get my pension plan money now that I agreed to split? Well, you go and you're ready to get that pension plan money, or you're trying to get money from that 401k that your spouse still controls, and you don't know what to do next. And it actually gets worse than that as well. Maybe your attorney says, well, go talk to these people about a quadro. Call up this firm or call up this person I use. And so you call them up, you pay some money to them, and then you say, they do the work for you. And then you submit the information to your spouse's plan. You say, all right, give me the money. Well, your spouse's plan could say, well, actually, what you agreed to in your divorce settlement, what you agreed to that the court signed off on, it's not legal. And that's not how we do things. So you're going to have to go back and renegotiate your settlement or do things differently. And it turns out that maybe months go by or years go by and you don't have access to funds that you thought of because you didn't listen to this episode, because you didn't know about quadros and you didn't know how essential it is to use and what its purpose is in the situation of divorce. And unfortunately, this isn't straightforward. No one goes to school, no one teaches you this, and most attorneys don't even help you out. And I see people where even years down the line, they still haven't gotten access to their money, or they have to reopen the divorce settlement and start negotiating and haggling over these things once again. And I don't want that to happen to you. So today we have some really special guests. We have the owners of QDRO Solutions, an attorney named Michael O'Connell and an associate named Donna Dodds. And they are some of the top experts in the United States when it comes to splitting retirement plans. And they specialize in this specific process we call a quadro. It's an acronym. QDRO stands for Qualified Domestic Relations Order. And the reason I have Michael and Donna on and their firm QDRO Solutions is actually the founder of their firm, a gentleman by the name of David Carrad, wrote the book. He's since passed away, unfortunately, but he wrote the book, The Nationwide Standard on Quadros and How to Split Retirement Plans in Divorce, that every family law attorney should be reading. If they aren't, that's a sign. I won't say that you have to read it, but you should definitely listen to the half hour of this episode because they're going to bring up a lot of really important points that you need to be thinking about and why there's so much complexity when it actually comes to splitting a retirement plan that I'm willing to bet your attorney didn't think about, I'm sure you didn't think about, and some stuff I didn't even know before going through this interview. And so if you have a pension plan, a 401k, an IRA, really any type of retirement account, you need to be listening to this episode, and you should be thinking about contacting an expert like QDRO Solutions. So without further ado, here's my episode with Michael O'Connell and Donna Dodds. Today on the show with me, I have Michael O'Connell, a lawyer and owner of QDRO Solutions, as well as his associate, Donna Dodds. Welcome to the show.
Thank you, Sean.
Thank you.
Why don't you tell us a little bit about your firms, your respective backgrounds, and what QDRO Solutions does?
I'm a lawyer in Charleston, South Carolina. I've been practicing continuously in South Carolina since 1975. I've had a varied career, including 15 years in state and federal public defender's offices. But in 1996, I left the federal public defender's office and went into practice with Ann Sterling, who's retired, but was one of the, if not the premier family court lawyer in South Carolina. She's also my wife. And so when I did that, I knew what was going to happen, which was a large percentage of my clientele was going to become family law cases. So as it evolved very quickly, at least 50%, and oftentimes much more of my caseload were domestic cases, family law cases, divorces, custody, division of marital property, which is what we're here to talk about today, at least as far as pensions are concerned. Anne retired in 2015. I'll say transferred the business to me. It was a pretty good price. And I've been owning and operating it ever since. Donna?
Well, I am a legal assistant, and I have been a legal assistant for probably 35 years. I came to work for Ann Sterling January of 1995, and I've been with Sterling and O'Connell Law Firm since. When Ann decided to purchase QDRO Solutions from David Carrad, who is what we call the guru of quadros. Mr. Carrad came and personally trained on how to do quadros of every kind. And that's what we've been doing ever since.
That's great. I actually have read David Carrad's book, and it is extraordinarily detailed on quadros, and I'm glad you've worked in the field for such a long time, because it's a pretty extraordinarily complicated area of the law and of divorce.
I do call David's book my Bible.
It's invaluable for us because it is quite complex. I took income tax in law school, and it's very much like reading the IRS code. It is the only source of the information we need. It's the only one out there. David unfortunately passed away in April, but until he passed away, which I believe was quite sudden, he was a consultant for the last eight years. Ever since Ann acquired QDRO from him, he signed on as a consultant. He was invaluable to have and taught us a lot over the years.
That's great. So for most of the people listening, they don't know necessarily what a quadro is and what we're about to get into. And so why don't you tell us, I think you mentioned pension plans briefly, but if you have certain types of assets, when might you need this quadro? And also give us just a quick definition of what quadro even means, because we're going to be using the term quite a bit.
All right, a quadro is a qualified domestic relations order, and I'm going to give you a brief history of why they exist. Prior to 1974, there was no protection for pensions for the employee. You could go to work for somebody and they promise you a pension after you stayed there for 30 years, and they could fire you with 29 years, 364 days, and you had no protection, no pension. It was gone. So in 1974, the Congress enacted the ERISA Act, which is Employment, Retirement, and Income Security Act, which protects the employee's pension, and it has tax advantages for both the employer and the employee. The employer can, to the extent they pay into a pension system, deduct that as a business expense. And as we all know, you've made contributions to your pension plans or your 401k for the employee. They're not taxable until you take them out at retirement, when presumably we'll all have lower tax rates. When people divorce, those pensions are marital property to the extent the marital portion is. That is the portion that existed or that had gained value during the course of the marriage. And they're divided by courts. About 95% of family law cases, the divorce is settled by agreement after negotiation or mediation. And those negotiations, in part, divide the pensions, 401ks, and the pension plans. And the reason there are protection is that for the litigants, I'm going to call them the husband and wife, is that when the pension is divided between them, it's a non-taxable event. Ordinarily, if you take money out of your pension or 401k before age 59 and a half, you get taxed on it. And so in 1975, I think it was, in order to solve that particular problem, what is called the Retirement Equity Act, or the RAA, was enacted. It amended ERISA and the IRA, Internal Revenue Service Code, that provide that upon divorce, that the division of pensions would not be taxable, provided that there was a qualified domestic relations order, and that's pursuant to federal law, not state law. The feds have specific requirements that are necessary to be of those orders in order to qualify and to make the transfer from the participant. Well, let's in this case use say the participant is a husband. Husband has a pension with his employer, and it's going to be divided. And say the wife gets 50% of that by negotiation or by court order if they have a trial. Then that state court order is drafted and signed by a judge, and then they come to us and ask us to draft a quadro, which qualified domestic relations order, which ultimately is submitted to the plan administrator. Most companies outsource their pension plans to plan administrators, and the plan administrator tells us whether they'll accept it or not. And then once it's accepted, we send it back to the lawyers to get signed by a judge. Then the qualified domestic relations order, once it's signed by a judge, this is all after it's been approved by the plan administrator, sent back to the plan administrator, and the division of the pension plan is completed by the plan administrator. That may be more than what you asked.
No, that's actually a great answer, because it gives a lot of follow-up areas that I want to dig into a little bit more with you. So if I'm listening right now, it sounds like if I have a pension plan or a 401k plan and it's going to be divided and divorced, those are the times where I might need, I will likely need or will need a quadro. Is that right?
You absolutely need it. The person who suffers if the plan is divided without a quadro is the person who owns the plan, who owns the pension. They're the ones who are going to have to pay the taxes on it. And there's no need for them to do that with a quadro. And so it's essential. Nobody wants to pay taxes, period, but nobody wants to pay taxes until they have to. And, the theory behind pensions, and at least part of the theory, is that you'll get them at retirement age when your taxable income bracket is lower than it was during your working career. So it's essential. There's not really any doubt, any question about it.
Got it. And then what about for IRAs? Do you need a quadro in that case as well?
Yes, because, you do. That's just really what the law requires. Treated very much like 401ks when it comes time to divide them. But yes, you do. I might add something. Let's suppose the 401k is being divided between a husband and wife, and the wife is going to be what we call the alternate payee. The husband's the participant. That is, he's the one who owns the IRA through either privately or through his employment. The wife can take, as long as she gets it directly from the husband's plan, she can take any amount of that out in cash. She has to pay income tax on whatever she takes out in cash, but she does not have to pay a 10% penalty, which would ordinarily be imposed on anyone else. But it has to be done at the right time. It has to be taken directly from the husband's plan in cash. I say cash, but an amount of money in order to avoid the 10% penalty. You still got to pay the taxes on it in any event. Once you reach 59 and a half, there is no 10% penalty for taking any portion out in cash.
I think that makes sense. That's a clever trick for people who need to pursue that option. let's say I have some sort of retirement plan. Why can't I, come up to get my divorce settlement and we're about to sign it and everything's negotiated. And then it's like, oh, well, we got to split this plan up. So we give you a call. Is that the way it should work or do I need to plan ahead?
Yes, they should really contact us before they draft the agreement, because lots of times agreements we get are drafted and signed by a judge. They're made in order of the court by a judge, and they call for something that can't be done. It is legally impossible. And I'll give you a brief example. We recently had a state of South Carolina retirement system division, and the alternate payee, that is the wife, wanted half of the vested amount in the pension plan. And I can't remember what the amount was, but she wanted 50% of it. And so that's what the agreement said. And then the judge made that agreement the order of the court. That can't be done. The South Carolina retirement system would not give her 50% of the vested value of that retirement plan as a lump sum. We went back, told the people what they had to, that what they wanted to do couldn't be done, and they had to figure out some other way of dividing that pension, or maybe substituting other assets for what she would have gotten out of the pension, assets that went to the husband in the divorce agreement in order to make up for that. I don't know. Donna, do you know what they did? Have we ever heard from them again?
No, they were going to go back to the drawing table, and what that causes is an extreme delay for the people to get the retirement divided properly.
And not only that, another problem is we have people who come to us years after the divorce agreement has been made the order of the court. And often it's not lawyers, it's the people who want their money. It's the alternate payee. In most cases, it's the wife. If it was a pension plan that was divided, the husband's pension plan that was divided. And it'll contain language like we just spoke about. It will contain language that can't be done. You can't divide it the way they have it in the agreement. And what do you do then? Because technically speaking, and legally speaking, actually is a better word, the family court, at least in South Carolina, would have lost jurisdiction under ordinary circumstances to change the order, because there's a time limit for courts to have jurisdiction over matters. In South Carolina, there is a rule called Rule 60. You can do it up to a year if it would be what is called inequitable for the agreement or the order to remain in effect. You can change it. But after that year, you're not supposed to be able to change it. So you can agree in principle on how something's going to be divided, but then call us before the agreement is executed by the parties.
We will actually, when hired, we will actually review their drafted language in the agreement and make sure that it covers everything that should be covered in that order. Because once that agreement becomes an order of the court and we are hired to draft the quadro, we are going to draft it based on what's in that court order. So it's important that lawyers in particular who are helping their clients contact us first, and so that we can make sure that they're putting the proper language in that's going to protect the people and give them the most that they can out of these retirement.
Yeah, I'm going to jump in for just a second. I think that makes a lot of sense. So what happens is, as soon as you have an idea, when I'm speaking a husband and wife and they're getting divorced and they kind of know more or less how they want things to be split, they should be giving you a call, because they could end up in a situation where, even in some cases, not immediately if you're not paying close attention, but potentially immediately, or potentially years down the line when you finally figure this out, that what they've agreed to can't actually happen for legal purposes.
Right.
And with that said, so let's say I'm in that stage where I'm kind of coming to an agreement, and we might not know 100% of the details, but we know how we're formulating our ideas of how the retirement plans are going to be split. So we give you a call. So what's the process from there? What kind of information do you need? What do I need to have prepared to get this quadro in order?
if they already have an agreement in place and they've got a court order that approves that agreement, or for final divorce decree that incorporates their agreement within it, they would need to contact us. And at that time, I will provide them with what's called our quadro information form. This form is very important for us because it gives us the information we need in order to start drafting the quadro. Has each of their personal information, date of marriage, date of separation, date of divorce. What is the name of the plan that needs to be divided? That is very problematic sometimes. People will contact us and say, oh, I'm supposed to get part of my husband's 401k, but I don't know what the name of it is. Okay. So that is very important to get that form filled out, make sure they know the name of the plan that's going to get divided, and the company and the plan administrator. And if they don't know it all, at least give us as much information as they can so that we can research the rest. And so I send this form to them and I ask that they fill the form out, that they send it back to us along with a copy of their court order and any information, documentation that they might be able to get a hold of regarding the retirement plan that's going to be divided. It's very helpful to have like plan summary documents, and the participant, the employee, can get that very readily and put this in a packet to us, and we charge a flat fee. And when we receive that packet, we go to work immediately.
Maybe this is a question you didn't ask, but it can be quite important for them if they have a concept about they want to divide a 401k 50-50 or some percentage like that. That's what they're going to do. That's what they've agreed on. They should call us, find out what they specifically need to put in the court order or the agreement, rather. So we don't have to go back to them later and say, well, what about, for example, does the recipient of the share of the husband's pension, for example, does she get gains that might occur between the date of the order and the date of division of the 401k? Or does she incur any losses that might happen during that period of time? Most of the ones we get after the fact, they don't say anything about that. If you're dividing what we call a defined benefit plan, which is you know what you're going to get at the end of 25 years with an employer, you're going to get a certain amount of money. When you're dividing those, does the recipient, that is the spouse, is going to get a portion of that plan? Does he or she have rights of survivorship? When the owner dies, most of the ones we get to divide defined benefit plans don't have that language in them. So we kind of fly blind. We get the order, we do what the order says, unless it's something that cannot be done, and that's such a case we send it back. But it would be a lot better if we, for both sides, so they would, if they were to express their intentions to us, what do they want to do? Do they want to get some rights to survivorship? If the employee who owns the pension dies, does the wife, alternate payee, continue to get her portion of the pension payments? So these are pitfalls for lawyers they have to be careful about. And the best way to avoid most of these is contacting us before the agreement is written in stone, signed, executed, made the order of the court. And even before it's executed would be better, because once something's executed, the people, the parties to the agreement don't want to give anything up. They think they've given enough up. They don't want any changes in what's in the agreement frequently. And so that becomes a fight. It's not a fight we have, but it's a fight I think that I know that the lawyers have between themselves and with their clients frequently.
No, unquestionably. It sounds like there are a lot of just moving parts and things that aren't intuitive that you might have to think about if you haven't planned in advance. And assuming I contact you and I filled out the forms and you have all the information you need, how long is the typical process from when Quadro is submit to the plan administrator to, let's just say, me having access to the funds that we agreed upon?
As far as getting the packet and drafting the quadro, we pretty much do that within a week.
Mm-hmm.
And then what we will do is send the draft out to the parties and say, look at it, make sure that you think it conforms with what your agreement was. And then when you let us know that you seem to think it looks in order, we will send the draft to the plan administrator so that they can review and pre-approve it up ahead before anybody signs off on the quadro. That's important. Every plan is different. Every plan administrator is different, and you'll send them a draft of a quadro, and sometimes they want one word out or another sentence put in. And so we highly recommend that occur, that we be able to send it to the plan prior to the execution of the quadro. That's where it gets hung up a little bit because plan administrators don't immediately get back to you. We generally see that it takes at least 30 days before we'll get a letter from them letting us know about pre-approval. Sometimes they take more, but what's important and what we do as part of our job is to stay on top of it. We don't let it sit. If we're not getting a response within 30 days, we're calling them saying, where is this? We haven't gotten a response from you. When are we going to get one? So we do stay on top of that to get it pre-approved. And once it's pre-approved, we give it back to the parties. We draft quadros nationally, and every state is different as far as where you go, what court you're in as far as getting the quadro submitted to a judge. So once we receive pre-approval, we send it back with instructions of getting it signed, taking it to the court, getting it approved by a judge, and receiving certified copies of that court order. Once you have certified copy in hand, then you're ready to send it to the plan and say, here you go, this needs to be processed. I can't tell you exactly how long every plan takes before they actually, quote, qualify that quadro, but generally, I think within about a month's time at most, I think people are getting their distributions.
I need to, it's not a correction, but an expansion of one thing I told you before, which was the taking money out of a 401k in cash. The recipient does that at the time of distribution from the participant, that is the person who owns the pension plan. They have to pay the income tax, but they don't have to pay the 10% penalty. That's not true for IRAs. It's true for 401ks, but it's not true for IRAs. You always have to pay the 10% penalty if you get any portion of the IRA out in cash prior to age 59 and a half. Now, you might want to ask me why that is. I have no idea. That's just the way that's what the law is, and they should take it up with their congressman or senator. It doesn't make any sense, but I will tell you that that's what the law is.
No, this is all very helpful information, and there's just so many different things and moving parts and things to think about, and it's not clearly an instantaneous process. You do your jobs, but even then, it takes the court time to do its job, and then the plan administrator to do their jobs, and so it's not like overnight, once you get divorced, you have a bunch of money in hand, and so these are definitely great things to think about and to hear. For people who want to learn more about you, Michael, Donna, and QDRO Solutions, where should they go?
Our website is www.quadro, that's QDRO Solutions.net, not .com, .net. And it's a pretty good website. It's very informative. Or they can call us directly at 843-224-5720. But the best way is probably by the website, because you can directly contact us through that. And there's forms on there to fill out if you already have a court order. Go on. And
it has our phone numbers, everything on there, on the website, www.quadrosolutions.net.
And one last question as we wrap up. Do clients usually call you, or is it attorneys? Who do you work with the most?
It varies. The problem that we see is that attorneys think that once they walk out of that courtroom and they've got the parties divorced, that's the end of their job. And they say, okay, well, Miss Jones, if you need a quadro, you need to contact a company, QDRO Solutions or whatever, to do the quadro. And they just leave them hanging. People don't even know what quadros are, or so it's a problem. We have a lot of attorneys. I'd say it varies. It's probably 50-50 people calling us directly or their lawyers.
What lawyers need to do is stick with their clients through this process and not to say, you got to go get a quadro to divide this pension, to get your money. Because that's really what people are looking for. How do I get my money? And they say, well, get a quadro. And we frequently get people who call us up and say, well, I was told I need to get a quadro in order to get my money. And that's all they know. And it really ought to be the lawyer that sees the client through this process. Because sometimes, as we've explained, what they send us can't be done. It's got to be changed, if it still can be changed. Or they didn't clearly express their intentions about whether the alternate payee is the person who's getting the portion of the pension is going to get gains and losses. It's going to get in defined benefit plans. Is going to have rights of survivorship, cost of living adjustments that the participant is going to get during the time the pension is paid out. So those are the reasons why the lawyers ought to stick with the clients. What happens is, in effect, when people call us up and the lawyers have stepped out of the picture, we end up doing some of the work that the lawyers ordinarily should have done. That's why this QDRO Solutions is owned by a lawyer. I don't know if it's practicing law, but it's close enough. And a lot of people believe that it should be owned by a lawyer in any event. With me, our clients have the benefit of somebody who practices family law and has been continuously since 1996. I still practice family law actively, and I don't get easy cases. Sometimes I pine for easy cases. It's just not what comes this way. Everything I get seems to be complicated, and almost all of them, I would have pension issues.
No, I think that's great advice and great information. Well, Michael and Donna, thank you so much for coming on the show today.
Thank you for having us.
Thank you.
Take care.
We're almost done with the episode, but don't leave quite yet. Before you go, I want to make sure that you get the help you deserve. All you have to do is go to divorceandyourmoney.com, and the first thing that you do when you get there is sign up for the email list. You'll see a little box that says get updates and tips, and I will send you exclusive articles, content, and information that you will not find anywhere else, and it gets to go directly to you. The second thing that you do is consider getting one-on-one financial coaching. Look, divorce attorneys are good, but attorneys are not financial experts, and they can make many financial mistakes. I mean, even in the last episode, did they explain these details to you? Did they even bring them up, consider them? And I understand, because finances are really, really complicated. That's why there's over 100 episodes explaining different financial concepts, and sometimes you get to the point where the general information in the podcast, while helpful, you have the question is, how does it apply to me? How does it apply to my situation, my life, and my divorce? And the only way to find out is to go for the one-on-one coaching sessions where I get to help you across the United States, whether you're in California, Texas, Ohio, Illinois, Florida, New York, everywhere in between. We work by phone, email, and in person. All you have to do is click on the coaching tab and fill out a few short questions, and we'll set up an introductory call to see if I can help you. The sooner you get started, the better. Even if you're still preparing financial information or waiting on your spouse to prepare financial information, we can help with that. Or if you're in the middle of negotiating and trying to decide what's right for you. But here's the deal, is once you've signed on the dotted line, the mistakes today are pretty much permanent. And I don't want you to make costly mistakes during divorce. So be sure to consider the coaching, and the sooner you get started, the better off you will be. Finally, on divorceandyourmoney.com, there's just a ton of great resources on there. You can subscribe to the podcast, and if you have iTunes, leave a review, which helps other people discover this free information. I'm your host, Sean Lehman, MBA and Certified Divorce Financial Analyst. Thank you for listening.
Take it up, take it over, take